She was already photographing my house when I stepped onto the porch. No knock, no wave, no, excuse me. Just a woman in a navy polo with a subdivision logo on the chest, clipboard tucked under one arm, phone raised, snapping pictures of my siding like she was documenting a crime scene. Two men flanked her, board members, I'd learn later. One held a tape measure. The other had a manila envelope. I came down the steps. Can I help you? She didn't look up. You're in violation of 12 HOA architectural standards. Paint, fencing, that structure in the back, your driveway surface. She rattled it off like a grocery list. You have 30 days to bring this property into compliance or we begin lien proceedings. The one with the envelope stepped forward and held it out to me. I took it. Inside, a stack of itemized fines totaling $14,800. Paint color, non-approved, fence height, 2 inches over code, unauthorized accessory structure. That was my father's tool shed, the one he built with his own hands in 1981. An unpaved driveway. Apparently gravel wasn't good enough for the neighborhood my family's land had been part of for 50 years. I looked at her. I never signed an HOA agreement. That's when she finally made eye contact. She had the kind of smile people wear when they think they've already won. You're inside the subdivision boundary, she said. That means you're under HOA jurisdiction whether you signed or not. 52 homes follow these rules. You don't get to be the exception. One of the board members chimed in. Younger guy, polo tucked too tight, arms crossed. We can make this very expensive for you if you want to be difficult. I said nothing to that. Karen, and I'll call her Karen because her real name doesn't matter and the type certainly does, turned and pointed toward the rows of new homes stretching east across what used to be open pasture. The last phase had just been completed. Sod crews were still laying grass on the final lots. She swept her hand across the view like she was showing off a kingdom. This community is worth $11 million in assessed value, she said. Your little setup here is dragging property values down. Fix it or we'll fix it for you. She said that standing on my porch, on my gravel, on land my father paid for with 30 years of factory paychecks. I didn't raise my voice. I didn't clench a fist. I looked at the manila envelope in my hand, then at the 52 rooftops lined up across my east field, the field where my father used to cut hay every June, and I said, I'll read through your paperwork. She took that as surrender. I could see it in the way her shoulders dropped, the way she turned to her board members with a little nod, the way she walked back to her black SUV like she'd just closed a deal. She didn't even say goodbye. When she reversed out of my driveway, her tires spun on the gravel and kicked a spray of small rocks onto my porch steps. She didn't notice or didn't care. I stood there and watched her drive back toward the subdivision entrance, past the rows of beige and gray houses, past the manicured lawns and identical mailboxes, past the big stone sign that read Grandview Estates, a planned community. Planned. That was the word that almost made me laugh. Because here's what Karen didn't know. Here's what none of them knew. Not the board members with their tape measures, not the developer who sold those lots, not the 52 families who signed their mortgages and moved their kids into bedrooms and hung pictures on walls and called it home. Every single one of those foundations, all 52 of them, was sitting on dirt that had my family's name on it since 1974. I'd known it since the first bulldozer cut into my east pasture 3 years ago. I'd watched them grade the land, pour the slabs, frame the walls, run the plumbing. I watched the driveways get poured and the landscaping go in and the sold signs go up one by one. I watched families move in. I watched Karen get appointed HOA president by the developer and start handing out fines before the paint was dry. And I let it happen. Not because I didn't care, not because I didn't know, because my attorney told me something I never forgot. Let them finish. Every house they complete is another zero on the check they'll have to write you. I went back inside, walked past the hallway closet where the fireproof lockbox sat on the top shelf, the one with my father's original deed inside, and I poured myself a cup of coffee. She'd be back. They always come back when you don't bow. And when she came back, when they all came back with their lawyers and their liens and their courtroom confidence, I'd be ready. I had something in that lockbox worth more than every single one of their 52 houses combined. I just needed them to push hard enough to use it. 3 years before Karen showed up on my porch with her clipboard and her confidence, the land east of my house was nothing but open pasture. 40 acres. My father bought it in 1974 with money he'd saved working the floor at a brake pad factory in Dayton. He wasn't a farmer. He just wanted land. Somewhere quiet, somewhere his, somewhere nobody could tell him what to do. He built the house on the northwest corner that same year, added the tool shed in '81, when he finally had enough for lumber, and spent the rest of his life mowing hay on the east field every June because he said it kept the land honest. When he passed, I inherited the whole parcel through probate. Clean transfer. No disputes. I moved into the house, kept paying the taxes, and left the east pasture alone. For nearly 20 years, the only thing that changed on that land was the height of the grass. Then one Tuesday morning, I drove out to check the fence line and found orange survey stakes running across my east field. I hadn't ordered a survey. Nobody had called me. Nobody had knocked on my door, slid a letter under it, or left a voicemail. Just stakes, bright orange, evenly spaced, stretching from the tree line all the way down to the creek bed. Within a week, a grading crew showed up, 3 machines. They started cutting into the pasture from the south end, leveling the ground in long, parallel strips. I stood at my fence and watched a man in a hard hat direct a bulldozer through the spot where my father used to park his tractor. I drove to the county recorder's office that afternoon. What I found there is the reason this story exists. The developer was a company called Grandview Development, LLC. They'd been buying parcels in the area for a master plan subdivision. 52 single-family homes, paved streets, community entrance with a stone sign, the whole package. According to their file documents, they'd purchased the parcel from a company called Stonebridge Holdings. Here's the problem. Stonebridge never owned my land, not 1 square foot of it. What Stonebridge had was a neighboring parcel, about 15 acres to the south. At some point, either through incompetence or something worse, they included my 40 acres in the legal description when they sold to Grandview. The deed from Stonebridge to Grandview looked legitimate on paper. It had a legal description, it had signatures, it was recorded. But it was what real estate attorneys call a wild deed. A deed from someone who never held title in the first place. It's like selling someone a car you don't own. The paperwork might look real, but it doesn't make the car yours. My father's deed, recorded in 1974, chain of title unbroken for 50 years, superseded it entirely. Legally, the Stonebridge to Grandview transaction was a ghost. It transferred nothing. I called a real estate attorney named David Aldridge. Old firm, small town, the kind of lawyer who still keeps paper files and answers his own phone on Thursdays. I brought the deed, the county records, and a printout of the developer's filed plat. He spread them across his desk, put one next to the other, and didn't say anything for about 2 minutes. Then he looked up and said, "How far along is the construction?" "They just started grading." He nodded slowly. "You have 2 options. File an injunction now and shut it down. They'll owe you for trespass and site damage, but it won't be much. They've barely broken ground." He paused. "Or you wait. Or you..." "Wait for what?" "For them to finish." He leaned back. "You're under no legal obligation to stop someone from making their own mistake on your property. But if you let them build, every completed home becomes a liability they can't undo without writing you a very large check. 1 house is a boundary dispute. 52 houses is a catastrophe." I sat with that for a long moment. It wasn't the money that made me decide, it was what I found next. I pulled the developer's HOA filing from the county records, the one they submitted with the subdivision plat. The planned HOA would govern the entire community. And on the boundary map attached to the filing, they'd drawn my farmhouse inside the HOA zone, not adjacent, not bordering, inside. They weren't just building on my land. They were planning to make me follow their rules on property I already owned. That's when I told David, let them finish. Over the next 3 years, I watched it happen. Phase 1, Phase 2, Phase 3. Streets poured, houses framed, roofs shingled, driveways set, families moved in. A stone sign went up at the entrance. Grandview Estates, a planned community. And the developer handpicked a woman named Karen to be the founding HOA president. Former property manager moved into one of the first completed homes and started enforcing rules before most of the neighbors had finished unpacking. Within weeks, violation notices were going out. Lawn height, mailbox style, trash can visibility, holiday decoration approvals. I watched it all from my porch, the same porch my father built, on the same land he paid for, the land they were all living on without ever asking who it belonged to. And I kept paying my taxes every year, on time, like my father taught me. 6 months later, Karen came back. This time she brought a letter. Certified mail, return receipt requested. The envelope had the Grandview Estates HOA logo in the upper left corner, the same logo on her polo, the same logo on the stone sign at the entrance. She was branding her authority onto everything she touched. I opened it at my kitchen table. Final architectural non-compliance notice. The language was stiff and legalistic, the kind of phrasing someone uses when they want you to feel small. It listed 4 violations and 4 demanded corrections. First, exterior paint. My house was weathered blue, the same blue my father chose in 1974. The HOA required all homes to be painted in one of 4 approved earth tones. Estimated cost to comply, around $4,000. Second, my father's tool shed, listed as an unauthorized accessory structure constructed without architectural review. They wanted it removed. The shed that had been standing on this land for over 40 years, built before the HOA existed, before the developer existed, before Karen had probably graduated high school. Third, gravel driveway. All driveways within the HOA boundary were required to be paved. concrete or asphalt. Estimated cost $8,000 to $10,000. Fourth, fence height. My back fence was 2 inches above the 4-foot maximum. They wanted it cut down or replaced. Total cost to comply if I did everything they asked, north of $20,000. At the bottom of the page, a single paragraph in bold. Failure to achieve full compliance within 15 days will result in the filing of a property lien and may lead to foreclosure proceedings as permitted under the HOA governing documents. 15 days to repaint a house, demolish a shed, pave a driveway, and rebuild a fence. Even if I'd wanted to comply, which I didn't, the timeline was designed to make it impossible. That was the point. The deadline wasn't meant to give me a chance, it was meant to give them a reason. I photographed every page, front and back, time-stamped. 4 days later, Karen showed up in person. She stood at the edge of my property line, not on the sidewalk, not on the street, right at the line where my gravel met the HOA's landscaped curb. A board member stood behind her. Same guy as last time, arms crossed, polo tucked tight. She had her clipboard again. She always had the clipboard. 2 neighbors were outside. A retired man named Harold, 72, mowing his front lawn across the street, and a younger woman 3 houses down, pulling weeds from her flower bed. Both stopped what they were doing when Karen started talking, and Karen liked an audience. "Mr. Brewer," she said my name like it was a violation. "Your 15-day window is already running. I want to be very clear about what happens if you don't comply." I was standing on my porch. I didn't step off it. "This isn't optional," she continued. "You live within this HOA. You agreed to these standards by residing here. We have the legal authority to place a lien on this property and pursue foreclosure if necessary." She lifted the clipboard and tapped it once like a judge with a gavel. "I've already spoken with our attorney." The board member added, loud enough for the neighbors to hear, "It's really in your best interest to cooperate." I looked at Harold across the street. He'd stopped his mower. He was standing with both hands on the handle, watching, not moving. The woman 3 houses down had gone still too. They weren't watching out of curiosity, they were watching out of fear. The kind of fear that comes from recognizing yourself in someone else's crosshairs. I turned back to Karen. "I appreciate you stopping by," I said. "I'll review the notice with my attorney." She didn't like that. Her jaw tightened. "You can review whatever you want. The deadline doesn't move." She turned and walked back toward the subdivision. The board member followed. Neither looked back. After they left, Harold crossed the street. He walked slowly, like a man who wasn't sure he should be doing what he was doing. He stopped at the foot of my driveway and spoke quietly. "She got me for $600 last month," he said. "Birdhouse. Said it wasn't on the approved structures list." He shook his head. "I built that birdhouse with my granddaughter, painted it yellow. They said yellow wasn't an approved color." He looked over his shoulder toward the subdivision. "Nobody fights her. She's got a lawyer. She's got the board. She's got the bylaws. People just pay and shut up." I asked him why he paid. "Because I'm 72 years old and I can't afford to lose my house over a birdhouse." He went back across the street and started his mower again. That night I sat at my kitchen table with the compliance notice, the envelope, and a cup of coffee. I spread them out next to the photos I'd already been collecting. Construction progress shots, time-stamped images of every violation notice they'd sent, screenshots of HOA emails announcing rule changes. 14 months of documentation, building quietly in a folder I kept on my laptop and backed up to a thumb drive in the lockbox. I called David Aldridge the next morning, told him about the final notice, the 15-day deadline, the foreclosure threat. He listened. Then he said something that kept me steady for the next 2 years. "Every fine they issue you, every lien they threaten, it's all evidence of them asserting authority over property that isn't in their jurisdiction. They're building your case for you. Keep collecting." So I let the clock run. 15 days came and went. I didn't repaint, I didn't pave, I didn't tear down my father's tool shed, and I didn't lose a single minute of sleep. 18 months after that first bulldozer cut into my east pasture, the subdivision was almost complete. 48 homes finished, families in every one of them, kids riding bikes on streets that were poured over soil my father used to walk every evening after dinner. 4 more houses still in framing, the last phase, the final lots at the far southeast corner near the creek bed. Sod crews and painters moved between them like ants finishing a colony. Karen's HOA had grown with every closing. 52 sets of CC&Rs signed, 52 families who checked a box and handed over monthly dues without ever asking one simple question. Who actually owns the ground under our house? Not one of them asked. Not the buyers, not the title company, not the developer's attorneys. Nobody pulled the original chain of title. Nobody walked into the county recorder's office and checked whether the land beneath $11 million worth of real estate actually belonged to the man selling it. I did. On a Tuesday morning in March, I drove to the county recorder's office and requested a certified copy of my father's deed. The clerk pulled it in about 10 minutes, Book 14, page 331, recorded August 1974, legal description covering the full 40-acre parcel, meets and bounds, reference markers, the whole thing. My father's name is grantee. My name added through probate in 2001, unbroken chain, no gaps, no competing claims on file. I asked the clerk one more question. Is there any other recorded deed covering this same legal description? She typed for a moment. There's a deed from Stonebridge Holdings to Grandview Development LLC, recorded 3 years ago, but it references a different chain of origin. She looked at me over her glasses. Yours is senior by about 50 years. I thanked her and left. That afternoon, I sat with David Aldridge in his office. He'd already ordered a title report from a title insurance company. The results were clean and brutal. My chain of title, valid, unbroken, recorded, senior. The developer's chain, broken at the Stonebridge link. The title company confirmed what David had told me on day one. The Stonebridge deed was a nullity. Grandview had built an entire subdivision on a ghost transaction. David set the report down and said, when you're ready, this won't even be a close case. I wasn't ready yet. 4 more houses to go. While I waited, I did something I hadn't planned on doing. I started getting to know my neighbors. Not about the land. I never mentioned the deed, the title chain, or the lawsuit I knew was coming. I just started being a person on the same street. Harold was first. One afternoon, I saw him on a ladder trying to clean his gutters. 72 years old, one hand on the ladder, one hand on a leaf blower that was winning the fight. I walked over and held the ladder. We cleaned them out together. Afterward, he sat on his front step and told me he'd been a postal worker for 31 years. Bought this house as his retirement home. First place I ever owned, he said. Karen makes me feel like I'm renting. Then there were Jake and Maria. Late 20s, first-time buyers, baby due in 3 months. They'd bought in phase 2 because the payments were lower than rent and the school district was decent. Their problem was parking. They had 2 cars and a 1-car garage, and Karen had started tagging vehicles parked on the street after 10 p.m. with orange violation stickers. Jake got 2 in 1 week. Each one came with a $75 fine. I told them they could park their second car on my gravel driveway. Jake looked at me like I'd offered him a kidney. You sure? She'll probably fine you for that too. Let her try. And then there was Diane. Single mom, 2 kids, worked the night shift at a distribution center. Diane's violation was the one that made my jaw tighten. Karen had fined her $1,200 for leaving her trash can visible from the street for 4 hours on a non-collection day. Not overnight. 4 hours. Diane had gotten home from a 12-hour shift, pulled the cans in from the curb, and left them beside her garage while she went inside to sleep. By the time she woke up, there was a notice on her door and a fine in her mailbox. $1,200 because a tired woman didn't drag a trash can 6 more feet before she collapsed into bed. That's when I saw the full picture. Karen wasn't just enforcing rules. She was running a revenue machine. Fines funded the HOA. The HOA funded Karen's salary and her attorney's retainer. The attorney sent the threats. The threats kept people quiet, and the quiet kept Karen in control. The whole system was a loop, and every dollar came from people who were too afraid to push back because they thought they had no leverage. They didn't know that the man with the gravel driveway and the unpainted house had more leverage than all of them combined. But I couldn't tell them. Not yet. David and I had agreed. The moment I revealed the deed situation to anyone in the subdivision, word would reach the developer. And the developer's attorneys would shift from offense to damage control. Maybe even try to buy the land quietly or file preemptive motions to cloud my title. I needed them confident. I needed them committed. I needed them to keep building. 4 more houses. Framing almost done. Roof trusses going up on the last 2 lots. I called David. How much longer? Couple of months, he said. Maybe less. When they're done, call me. 48 down. 4 to go. Every nail they drove was another nail in their own coffin. And Karen, the woman who thought she ran this neighborhood, had no idea she was collecting rent on borrowed ground. The last house was finished on a Thursday in September. I knew because I watched the final inspection from my kitchen window. A county inspector walked the property, checked the boxes, signed the form. The contractor shook his hand. 2 days later, sod was rolled out on the last lot like a green carpet covering the last piece of my father's pasture. 52 homes, all done. Every phase complete. $11 million in assessed value sitting on 40 acres of land that not one of them had ever legally purchased. Karen celebrated. Of course she did. She organized a ribbon cutting at the subdivision entrance, right under the stone sign that read Grandview Estates, a planned community. There were balloons, a photographer from the local paper. The developer sent a representative in a suit who shook hands and smiled for the camera. Karen stood at the center of it all, scissors raised, grinning like she'd built every house herself. I wasn't invited. I watched the whole thing from my porch, about 300 yards away. Same porch my father built, same view, Except where there used to be hay, there were now rooftops, 52 of them, neat and symmetrical, lined up in rows like headstones. 2 weeks after the ribbon cutting, a certified letter arrived. The HOA had filed a lien against my property. Not a threat this time, not a warning. An actual lien, recorded at the county recorder's office, attached to my title. $14,800 in unpaid fines, paint, shed, driveway, fence. The same list they'd been reciting for over a year, now carved into my property record like a scar. I held that document in my kitchen and read it twice. A lien on a house I'd owned for 23 years, filed by an organization that existed on land my family had held since before their developer finished middle school. 3 days later, a second envelope arrived. This one from the developer's law firm, a downtown office with 3 names on the letterhead and a font designed to intimidate. Inside was a cease and desist letter. I read it standing at my mailbox. The letter stated that my farmhouse was an unauthorized structure within the planned community, and demanded I submit to architectural review or face legal action to compel compliance and, if necessary, removal of non-conforming structures. Removal. They were talking about demolishing my house, the house my father designed on graph paper at his kitchen table, the house he poured the foundation for himself, with help from 2 friends and a rented cement mixer. They called it non-conforming. I drove to David Aldridge's office that afternoon. I put both documents on his desk, the lien filing and the cease and desist, and sat down across from him. David read the lien first, then the cease and desist, then he took off his glasses, set them on the desk, and did something I'd rarely seen him do in all the years I'd known him. He smiled. "They just filed a lien on your property," he said, "claiming HOA authority over your land. And the developer's attorneys just called your home an unauthorized structure on your own parcel." He tapped the cease and desist with one finger. "These aren't threats. These are gifts. They've put their fraud in writing, signed it, and recorded it with the county. You couldn't have asked for better exhibits." He was right. Every document they filed, every letter they sent, every lien they recorded, it was all evidence. Evidence of an HOA asserting jurisdiction over property it had no legal right to govern. Evidence of a developer claiming authority over land it had never legally acquired. They weren't attacking me. They were building my case for me, and they just handed me the receipts. I drove home, made coffee, sat on the porch. I want to explain something, because people asked me about it later. A lot. Why I waited so long. Why I didn't stop them at 1 house or 10 or 30. Why I let 52 families move into homes on my land before I did anything. Here's why. If I'd filed an injunction when the first bulldozer broke ground, it would have been a boundary dispute. A surveyor's error. Something the developer could fix, settle quietly, and walk away from. Maybe they'd have paid me fair market value for the acreage, and everyone would have moved on. Maybe they'd have redrawn the boundary and built 40 homes instead of 52. Either way, it would have been small, containable, forgettable. But 52 completed homes? 52 families who each paid around $300,000 for houses built on land the developer never owned? That's not a boundary dispute. That's not a surveyor's error. That's a catastrophe. The kind of catastrophe that doesn't get settled with a handshake. The kind that gets settled in a courtroom, on the record, with a judge looking the developer in the eye and asking, "How did you build 52 homes on someone else's property without conducting basic due diligence?" I didn't wait because I was greedy. I waited because I needed the mistake to be so large, so undeniable, so impossible to minimize, that no judge, no mediator, no developer's attorney could frame it as anything other than what it was. Negligence on a massive scale on my land. 2 weeks after the cease and desist arrived, it happened. The HOA, through its attorney, filed a formal lawsuit against me. Breach of CC&Rs, failure to comply with architectural standards, enforcement of the lien. They wanted a court order compelling me to repaint, pave, tear down the shed, and cut the fence. The filing described my property as a non-conforming parcel within the Grandview Estates community. The process server came to my door on a Wednesday afternoon. He handed me the papers. I signed for them, thanked him, and closed the door. Across the street, parked in her black SUV, Karen was watching. When I looked out the window, she caught my eye. She waved. That little wave, that satisfied, settled, we've got you now wave. I think about it sometimes. I think about how confident a person has to be to wave at the man they're suing on his own land they've been standing on, building on, profiting on, without ever once checking whose name was on the deed underneath. She'd find out soon enough. Karen told the neighborhood I was going to lose my house. She didn't say it in writing. She was too careful for that. She said it at the monthly HOA board meeting, standing behind a folding table in the community clubhouse with about 30 homeowners sitting in plastic chairs. I wasn't there. Harold was. He told me about it the next evening, standing in my driveway with his hands in his pockets and his voice low, like he was reporting from behind enemy lines. She called it the situation with the farmhouse, Harold said. Told everyone the lawsuit was moving forward and the court would handle it. Then she said, and I'm quoting her here, by the end of this process, we should expect a cleaner community entrance. A cleaner community entrance. That was how she described removing my home. Not a legal dispute, not a difficult situation, a cleanup. Harold said a few homeowners clapped. Most people didn't, he added quickly. Most people just sat there, but nobody said anything. Nobody asked a question, nobody pushed back. That was Karen's real power. It wasn't the bylaws, it wasn't the attorney on retainer, it was the silence she'd trained into the room. After 2 years of fines, liens, threats, and letters, she'd turned 30 families into an audience that knew when to clap and when to stay quiet. But not everyone stayed quiet, not anymore. The next morning, Harold knocked on my door again. This time, Jake was with him. Jake had his hands jammed into his jacket pockets and kept looking over his shoulder toward the subdivision like he expected Karen to be watching. "We want to come to the hearing," Jake said. No preamble, no small talk, just that. I looked at him. "You know what Karen will do if she finds out you showed up on my side of the courtroom." Jake shrugged. "She fined me $150 last week because Maria put a wreath on the front door and it was half an inch wider than the approved diameter. A wreath for our baby's nursery." He shook his head. "I'm done being afraid of a woman with a clipboard." Harold nodded. "Diane can't get off work, but she told me to tell you, and again, I'm quoting, give her hell. I didn't promise them anything. I didn't tell them what I had. I just said, it'll be worth the drive." Harold looked at me for a long moment. He'd been watching me for 2 years, watched me take the fines, ignore the threats, let Jake park in my driveway, help him clean his gutters. He'd never once seen me angry, never once seen me worried. I think that scared him a little. Not because he thought I was dangerous, but because he'd started to suspect I knew something nobody else did. He was right. That week, my attorney filed the counterclaim. David Aldridge had spent 3 months building it. Quiet title action. A legal proceeding to ask the court to confirm who actually owns a disputed piece of property. In plain English, we were asking the judge to look at both deeds, both title chains, and rule on which one was real. Ours was real, theirs wasn't. That was the whole case. But David didn't stop there. Alongside the quiet title action, he filed counterclaims for trespass, unjust enrichment, and slander of title. The trespass was obvious. 52 homes built on my land without permission. Unjust enrichment meant the developer had profited from property they didn't own. And slander of title covered the lien the HOA had filed against my property, a legal claim that had no basis and that damaged my title record. The deed was Exhibit A county tax records. 50 years of my family paying taxes on this land without a single lapse were Exhibit B. The developer's broken title chain was Exhibit C. And the HOA's own lien filing and violation notices were Exhibit D, evidence that they'd asserted authority over property they had no legal right to govern. David filed it all on a Monday. The hearing was set for Thursday of the following week, 9 a.m. courtroom 3B. Karen's side had filed nothing about title, not a single document establishing their own ownership. Their entire legal strategy was built on one assumption, that the HOA had jurisdiction over my property because my property sat within the subdivision boundary. They never questioned the boundary itself. They never questioned whether the developer actually owned the land the boundary was drawn on. They were about to walk into a courtroom arguing about paint colors and fence heights on property that belonged to me. The night before the hearing, I sat at my kitchen table. The house was quiet, the kind of quiet that only comes when you've been carrying something heavy for a long time and you know you're about to set it down. The deed was in front of me. I'd taken it out of the lockbox that afternoon. My father's signature was on page 3, careful, deliberate, the handwriting of a man who understood what he was signing. Below it, the notary's stamp, August 14th, 1974, Book 14, page 331. I thought about him. Not about the case, not about Karen, not about the 52 houses or the $11 million or the lien or the lawsuit, just about him. About the way he used to walk the East Field in the evenings, hands behind his back, checking on nothing in particular. About the way he talked about this land like it was a person. "You take care of it," he told me once, "and it'll take care of you." I slid the deed back into its envelope, put it in my bag, and went to bed. Tomorrow morning, 9 a.m., courtroom 3B. She'd walk in thinking she was about to take my home. I'd walk in with a piece of paper that said I owned hers. Courtroom 3B was smaller than I expected. Wood-paneled walls, fluorescent lights, the kind of industrial carpet that absorbs sound and dignity in equal measure, 2 tables facing the bench, a gallery with 4 rows of seating. The flag in the corner hung perfectly still. I arrived at 8:40. David Aldridge was already there, setting up at the respondent's table. He had one manila folder in front of him. That was it. One folder, 4 exhibits, and 50 years of unbroken title. Karen's side arrived at 8:50. They came in like they were winning. HOA attorney first, charcoal suit, leather briefcase, confident stride. Behind him, a paralegal wheeling a rolling file box stacked with tabbed binders. CC&R documentation, violation records, fine schedules, correspondence logs, the full machinery of HOA enforcement, organized and indexed and completely irrelevant to what was about to happen. Karen walked in last, navy blazer, pressed slacks, a leather portfolio under her arm. She sat behind her attorney and placed her hands flat on the table, composed, ready. She looked like a woman who had already rehearsed the drive home. 2 board members sat in the front row of the gallery behind her. Behind me, Harold settled into the second row. He'd put on a dress shirt. Jake and Maria sat next to him. Maria had the baby in a carrier on her chest, sleeping. Nobody spoke. The judge came in at 9 sharp. Middle-aged woman, reading glasses, no expression. She sat, opened the file, and nodded to Karen's attorney to begin. He stood and delivered exactly what I expected. Clear, practiced, routine. My property sat within the Grandview Estates subdivision boundary. I had refused to comply with the community's CC&Rs for over 2 years. I had accumulated $14,800 in unpaid fines. The HOA had filed a lien in accordance with its governing documents. They were asking the court to compel compliance and enforce the lien. He said it all like he was reading a recipe. Step 1, step 2, step 3. Karen nodded along with each point. When he finished, the judge turned to David. David Aldridge stood slowly. He didn't touch the manila folder yet. He looked at the judge the way a man looks at someone when he's about to change the temperature of the room. Your Honor, he said, before the court considers the plaintiff's claims, we have a threshold matter. The HOA attorney shifted in his seat, not alarmed, just noting the deviation from the expected script. David continued. The plaintiff seeks to enforce CC&Rs against my client and compel compliance with HOA architectural standards, but the plaintiff has no standing to make that claim. The Grandview Estates HOA has no jurisdiction over my client's property. He paused, because the entire subdivision, all 52 homes, was built on land owned by my client. The room didn't gasp. That's not what happens in a real courtroom. What happens is silence, a specific kind of silence. The kind where the air thickens and everyone stops breathing at the same time and the fluorescent lights suddenly sound very loud. Karen's attorney turned his head toward David like he hadn't heard correctly. David opened the folder. Exhibit A. He handed a document to the clerk, who passed it to the judge. The original property deed for the 40-acre parcel on which the Grandview Estate subdivision was constructed, recorded August 14, 1974, County Recorder's Office, Book 14, page 331. Grantee, Robert Brewer, my client's late father. Title transferred to my client through probate in 2001. Chain of title, unbroken. No competing claims, no lapses, no encumbrances. The judge looked at the document. She didn't react, but she looked at it for a long time. Exhibit B County property tax records showing continuous payment on this parcel by the Brewer family for 50 consecutive years. No lapse, no delinquency. Karen's attorney stood halfway up, then sat back down. He pulled his laptop toward him and started typing. The paralegal was already digging through the rolling file box, flipping tabs, looking for something. She wouldn't find it. They hadn't brought anything about title because they'd never questioned it. Exhibit C. David's voice didn't change. Same pace, same volume. The deed from Stonebridge Holdings to Grandview Development LLC, the transaction on which the developer based its claim to this land. Stonebridge Holdings never held valid title to this parcel. Their deed is what's known as a wild deed, a conveyance from a grantor outside the chain of title. It is, in legal terms, a nullity. It transferred nothing. Karen leaned forward and whispered something to her attorney. He held up one hand without turning around. Wait. Exhibit D. David placed the last document on the clerk's desk. The HOA's own recorded lien against my client's property, along with 23 violation notices issued by the Grandview Estates HOA over the past 2 years. We submit these not as evidence against my client, but as evidence against the plaintiff. Each document represents the HOA asserting legal authority over property it has no jurisdiction to govern. Every fine, every notice, every threat of foreclosure was issued on land the HOA does not own, has never owned, and has no legal right to regulate. That was the moment it hit Karen. Not the legal argument, not the exhibits, the math. I could see her doing it behind her eyes. 52 homes, $300,000 each, $11 million in assessed value. All of it sitting on land she'd spent 2 years pretending to control. Land that belonged to the man she'd tried to fine into submission. The man whose father's toolshed she'd called an unauthorized structure. She put her hand over her mouth. The HOA attorney stood. Your Honor, we'd request a brief recess to review the documentation that's been presented. The judge granted 15 minutes. Karen's attorney and the developer's attorney, who'd been sitting in the gallery and was now on his feet, moved to the hallway. Through the courtroom door, I could hear the conversation. Not the words, but the tone. Sharp, heated, the sound of people realizing they are standing in a hole they dug themselves. Karen didn't move. She stayed at the table, staring at the lien filing she'd been so proud of. The one that was now Exhibit D in a case against her own organization. After the recess, Karen's attorney stood and requested a continuance. He said they needed time to review the title documentation and assess the implications for the pending claims. David stood. Your Honor, the title has been recorded at the county recorder's office for 50 years. There is nothing to review. There is only what the developer failed to review before building 52 homes on my client's land. The judge looked at Karen's attorney for a long moment. Then she granted a limited continuance, 2 weeks, but added a statement on the record. The lien filed against the respondent's property appears to have been recorded without a legal basis. The court orders the lien suspended effective immediately, pending final resolution of the title dispute. Karen's lien, the $14,800 weapon she'd spent 2 years sharpening, was suspended in one sentence. The hearing was adjourned. Karen's attorney packed his briefcase without speaking. The paralegal wheeled the file box out. All those binders, all those tabs, all that organized irrelevance. Karen stood. She picked up her leather portfolio. She walked past me toward the door. She didn't wave this time. Harold was waiting in the hallway. He didn't say anything. He just extended his hand, and I shook it. His grip was firm. Firmer than I expected from a 72-year-old man. Jake stood behind him, one hand on Maria's shoulder. Maria had tears in her eyes. The baby was still asleep. Nobody said a word. Nobody needed to. The court ruled in my favor 3 weeks later. Quiet title judgment. The judge confirmed what my father's deed had said for 50 years. The 40-acre parcel, every inch of it, belonged to me. My chain of title was valid, unbroken, and senior to every other claim. The developer's chain was ruled defective at the Stonebridge link. The transaction that Grandview Development LLC had built its entire subdivision on was declared a legal nullity. One paragraph in the ruling said it plainly. The respondent holds clear and marketable title to the subject parcel. The plaintiff HOA's governing documents, including its CC&Rs, have no legal authority over the respondent's property. The lien was voided, not just suspended, voided. Every fine Karen had ever issued me was nullified. $14,800 erased in a single court order. The paint, the shed, the driveway, the fence, none of it was ever within her jurisdiction to regulate. David Aldridge called me the afternoon the ruling came down. He read the key language over the phone, then went quiet for a moment. Your father would have liked this one, he said. I think he would have too. The legal fallout for the developer was immediate and severe. The judge's ruling included a note, not an order, but a note, stating that Grandview Development LLC may face significant civil liability to the 52 homeowners who purchased properties built on land the developer did not legally own. That note was the judicial equivalent of lighting a fuse. Within days, 3 homeowners had retained attorneys. Within 2 weeks, a class action was being organized. 52 families, each paying an average of $300,000 for homes they were told the developer had every right to build. Total exposure for Grandview, north of $15 million. I want to be clear about something. Those 52 families were not my enemies. They never were. They were people like Harold and Jake and Maria and Diane, people who saved for a down payment, signed a stack of papers they trusted were legitimate, and moved their families into homes they believed were theirs. They didn't cause this. The developer did. The title company did. The attorneys who failed to conduct basic due diligence did. Those families were victims of the same negligence I was. The only difference was that I had the deed and they had the mortgage. David and I negotiated a settlement with Grandview's attorneys over the following 2 months. The developer purchased a long-term ground lease from me for the subdivision land, fair market value independently appraised, plus damages for trespass and unauthorized use of the property over 3 years. The total settlement was in the high 7 figures. I won't say the exact number because David told me not to, and I've learned that when David tells me something, I should listen. The ground lease meant the 52 families kept their homes. Their mortgages remained valid. Their property values were unaffected. The developer bore the financial consequence, not the families. That was the one thing I insisted on from the start, and David made sure it was written into every line of the agreement. The families would pay a modest annual ground rent going forward, pennies compared to their mortgage payments. Most of them didn't even notice the difference. A few came by the house to ask about it, and I explained it the same way each time. You're paying rent to the person who actually owns the land under your house. That's me, and I'm not going anywhere. Karen resigned as HOA president 4 days before the next board meeting. No announcement, no statement, no explanation. One afternoon, Harold saw a moving truck in her driveway. She was loading boxes into the back with her husband. They were gone by the weekend. I never spoke to her again. I don't know where she went. I don't need to know. The story she told herself about who she was in this neighborhood. The enforcer, the standard keeper, the woman who could fine a 72-year-old man for a yellow birdhouse and threaten to demolish a farmhouse that had been standing for half a century. That story ended in courtroom 3B. Everything after that was just packing boxes. The two board members who'd stood behind her resigned the same week. The remaining homeowners held a special meeting, a real one this time, without Karen controlling the agenda, and voted to restructure the HOA from the ground up. New bylaws, new leadership, an independent board elected by the residents, not appointed by the developer. Harold was elected to the new board. First thing he did was propose a motion to eliminate fines for cosmetic violations under $200. It passed unanimously. Jake seconded it. Diane sent me a card. Inside, in handwriting that leaned hard to the right like it had been written in a hurry, she'd written, "Thank you for not being afraid." I put it on my refrigerator. It's still there. A few weeks after the settlement was finalized, the new board voted to change the subdivision's name. The stone sign at the entrance, Grandview Estates, was taken down. They replaced it with something simpler. I won't say the new name, but it doesn't have the word estates in it, and it doesn't have a logo. Just a name and a street number. That felt right. I'm sitting on my porch as I tell you this. Same porch my father built in 1974. Same gravel driveway, unpaved, uneven, exactly the way it's been for 50 years. Nobody's going to make me pave it. The tool shed is to my left, where it's always been. 43 years old, built by a man who worked a factory floor so he could own a piece of land where no one could tell him what to do. It's still standing. Nobody's going to tell me to tear it down. The view to the east is different now. Where my father's hayfield used to stretch all the way to the creek bed, there are 52 rooftops. Families, kids, lawnmowers on Saturday mornings, the sound of someone's basketball hitting a backboard 3 streets over. I don't mind it. This land has people on it now. That's not the worst thing. Across the street, Harold's got a new birdhouse on a post in his front yard. Yellow. Same color his granddaughter picked the first time. Nobody said a word about it. 52 homes on my land. She thought that made her powerful. She didn't understand. It just made her wrong on a much bigger scale.